Hello everybody. Today we further discuss about National Company Law Appellate Tribunal. NACLET were established on 1st June 2016 under the Companies Act 2013. It is a quasi-judicial bodies in India that adjudicate issues relating to Indian companies. And the background is the Nclat consolidates the corporate jurisdiction of the Company Law Board, VIFR, AAIFR, and the power relating to winding up of restructuring and other provisions vested in high courts. Hence, the Nclat will consolidate all powers to govern the companies registered in India. The establishment of Nclat, the Company Law Board under the Companies Act 1956 has now been dissolved. Now the advantage of Nclat. First is speedy disposal of cases, second is reduction of undue hardships, third is single window, and fourth is reduction of burden on high courts. Benches of Appellate Tribunal. Total 15 tribunal benches in New Delhi, Ahmedabad, Allahabad, Hyderabad, Bengaluru, Chandigarh, Chennai, Cuttack, Guwahati, Hyderabad, Indore, Jaipur, Kochi, Kolkata, Mumbai, and one appellate tribunal in New Delhi. And tenure of their member is for the chairperson age of 70 years or such for a term of 5 years from the date on which he enters upon his office. For the judicial member tenure is age of 67 years or such for a term of 5 years from the date on which he enters upon his office. For the technical member age of 67 years or such for a term of 5 years from the date on which he enters upon his office. Now, let's discuss some cases upon Nclat. First is Vinod Singh Negi versus Kiran Shah, liquidator of Org Informatics Ltd. In this case, Nclat held that the rejection of the claim of the employee by the liquidator of corporate debtor under liquidation on the ground of such claim being bare by limitation. And the second case is Sri D. Srinivasa Rao versus Vaishnavi Infratech Ltd. In this case, held that case of corporate debtor, he refused to accept delivery of notice under Section 8 of the Code. The Nclat would not justify in holding that notice has not been served on the corporate debtor, as the fault would be lie on the part of corporate debtor for which it cannot be rewarded. Now, opportunity in Nclat. Nclat works on the lines of a normal court of law in the country and is obliged to fairly and without any biases determine the facts of each case and decide with matters in accordance with principles of natural justice and in the continuance of such decisions. Offer conclusion from decisions in the form of orders. Now, the power for the National Company Law Tribunal. The National Company Law Tribunal consolidates the corporate jurisdiction of the Company Law Board, Board for Industrial and Financial Reconstruction, and the Appellate Authority for Industrial and Financial Reconstruction, and the power relating to winding up or restructuring work. The National Company Law Appellate Tribunal is a tribunal which was formed by the central government of India under Section 410 of the Companies Act 2013. The tribunal is responsible for hearing appeals from the orders of National Company Law Tribunals starting on 1st June 2016. Now the challenge in front of Nclat. The writ jurisdiction under Article 226 of the Constitution cannot be invoked to challenge the order passed by Nclat held by the Division Bench of Honorable Justice S. Munikumar and Sazi P. Chelly in Sulochana Gupta and Ors v. RBG Enterprises Pvt Ltd. Thank you.